when you called the police, had you already seen the video?
Yes.
How did you didn't mention that, so how is it you see the video? Because you said he didn't say anything, but are you standing over his shoulder watching him?
No, the video is on a big screen that's outside of his office.
This is the plaintiff, Desreen Dookie. She says she brought her car to the defendant's car wash, and the machine broke the side view mirror of her car. She saw the whole thing happen. The unruly defendants refused to pay for the damages, and she's here suing for the $2,000 she surely owed. These are the defendants, Jessica Lodespato and Sarah Kafora. Jessica says this woman came into their car wash with an older car. They clearly state they're not responsible for things falling off older cars, and for all she knows, the woman's mirror could have been glued on. They washed 280 cars that day. No one else had a problem, and she's not paying this woman $2,000. They're accused of being all washed up.
All parties, please raise your right hands.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Milian in our forum, the People's Court.
People's Court is now in session. The Honorable Judge Marilyn Milian is now presiding. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome.
Okay, Ms. Dookie, what happened?
Hi, Your Honor. So I went through the car wash. The gentleman there lined up the car. He told us 3 things we had to do: take our hands off the wheel, put the car in neutral, and take your foot off the brake. As we're going through the car wash and the big brushes are spinning, it knocked my side view mirror off my car. And as we keep on going through the drive-through, the other big brushes from the big machines keep on knocking it till finally it came. Only one little cord was holding it onto my car.
Okay.
So I came out the car wash. I drove to the front office and I said, "Is there a manager here?" The manager came and he went straight to the office to review the camera, which I have the video of him reviewing the camera of my car. So I'm waiting, another 10 minutes. He came out. He never apologized, never said anything to me. Didn't introduce himself. He said, "What's your VIN number? And what's the year of your car?" I said, "It's a 2014. He goes, "Well, we don't fix car over 7 years old. And your car is 7 years old, so we're not responsible for it. So we're not going to do anything." So I called the police to get a report, and the police said, they can't force them to fix it. I just have to take them to court.
At this point, when you called the police, had you already seen the video?
Yes.
How did you didn't mention that, so how is it you see the video? Because you said he didn't say anything, but are you standing over his shoulder watching him?
No, the video is on a big screen that's outside of his office.
So you could see whatever it is.
I can see what he's clicking on.
You can see what he's clicking on from where you are. Okay.
Yes.
All right, let me hear from you folks. Were either one of you there, either Ms. Lodespato or Ms. Carfora?
We were not.
Okay. Who wants to talk to me first?
I could talk.
Okay.
So we did receive a call from Marcus. He did say that there was an incident. He's filling out a report. We did ask, what happened, and he said it was a 2014 BMW that came in. The side mirror fell off. He did review the camera. He said that after reviewing, he couldn't figure out if there was previous damage or not. He did call us. We do have disclaimers throughout the property.
He did review it and say, yeah, it broke in the car wash, right?
No, so it was very hard to tell. He did review the camera, but he could not tell if it was actually broken off inside the car wash or not.
Oh, let's see the camera. Let's roll tape.
Well, look at the video.
Hold on one second here. Hold on one
Well,
second.
that video is actually of my car going through, which is a 2012, to show that it doesn't even move.
Just a moment. You don't know what video I'm about to show you. Hold on a second. Whose car is this?
That's my car.
Exactly.
And you can see he's going to bike it all the way up, and you can see it. that it was perfectly fine going in there. The mirror was attached.
Hold on one second. Up on the screen is apparently whatever your guy is doing inside.
Correct.
Okay, so this is her car, correct? And this is her mirror intact.
Correct.
There's her mirror intact.
Right there, that big green brush knocked it off.
Okay, so that's it for the video, and then we have pictures of the thing hanging down right at the scene because she immediately tells you guys. So do you think that that doesn't show that it happened at the car wash, Ms. Lotuspoto? You think it's unclear?
And I didn't say it was unclear, but a lot of times there's previous damage that we're not aware of when people go through the car wash.
I just asked you if the video showed that it happened at the car wash, and your answer was, well, the video doesn't say, it's very unclear. And the video you have is the one I get. No, I also have the video she has, because you guys didn't know that I have the video, because you didn't give me the video, right? You didn't introduce the video into evidence, did you? You introduced your car as a demonstrative aid, right, Ms. Lotuspoto?
Yes, ma'am.
Exactly. But you have this video.
We actually don't have the video, unfortunately, because
how do you not have this video?
The videos only record for a certain period of time.
Are you trying to tell me that the manager of operations didn't bother to look at it at the time that it happened?
No, we did not.
Nobody bothered to look at it when this lady reported it?
No, we're actually quite busy running the business.
Right, well, so if somebody tells you you just destroyed my car, that's none of your business at Green Light Car Wash? I mean, your supervisor looked at the tape. That's why she was able to see it. So why wouldn't you know that the tape shows that it broke in your car wash? We'll talk about all your other defenses now. But it's just amazing to me that you don't just say, hey, sorry. Instead, I read this. 280 cars that day, and none were damaged. No other customer had issues, yada, 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 yada. The only thing, touchless, brushless, you know, blah, blah, blah. It's always the same thing, though, with these companies. Everybody always says, oh, there's no way anything can be ruined in a tow. No way, or all the other cars would have been ruined. There's no way anything could have been ruined in this car wash. No way, or all the other cars would have been. No, that's not truthful, because we just saw the video where your car wash broke the mirror. Now, before you smile too much, Miss Dookie, let's discuss the law, because you are limited by your agreement with them. If I had a 7-year-old car, I wouldn't go to their car wash anymore, okay? But you go to their car wash and they have signs everywhere that say, and actually what your signs say is not cars 7 years
It says
old
over
or
7
older.
years old.
It
My
says
car is not
over 7 years old or older. I don't know why someone wrote it that way. It's a dumb way to write it. You should redo your signs if what you meant was 7 years old or older. But your bottom line is that your 2014 is 7 years old the day 2021 starts. So I don't think you have much gas on that one. So is that what you were going to argue to me, Ms.
Well,
Dookie?
it says it was manufactured in October.
Manufactured in October of what year? It's a 2014, Dolly. It was manufactured back then. You know what? I've been doing this without you two for my whole life, and I'm not particularly happy with you. Ms. Dookie, when was the car manufactured?
2013, October 2013.
Right, so yeah, right? So you're out of gas, right? Because you know that the sign says, hey, if you're 7 years old or older, if you're
Your
older
Honor,
than 7 years old.
That's an 8x10 sign. That's not anywhere when you're driving through the car wash. It's on the side of the wall where you go to, if you want to vacuum your car. That's where the little sign is. A little 8x10 sign that's there.
All right, let's talk about where the signs are. So am I correct that I have one picture of a sign, or should there be more?
This is the same sign that's posted, but it is one picture.
Right, but where is the sign posted?
They're posted throughout the wall of coming up to the car wash.
That would have been good for you guys to photograph to show me that they're posted all over the place, right? Where are they posted?
Yes.
Go through each place that it's posted.
They're posted on the vacuum stations coming up to the car wash. They're posted as you come into the tunnel of the car wash as well.
So there's a second one there?
There's actually 4 or 5 throughout property.
I need to know where they are. That's my question. Can you answer that?
By the pay station. There's 2 different areas to vacuum. There's one by the pay station and one at the entrance of the tunnel.
So there's 4.
Correct.
Okay. Ms. Dookie, did someone bring those signs to your attention on that day? He told you, right? Like, hey, look at the signs, right?
When he said that, your car is over 7 years old, so we're not responsible for cars over 7 years old. That's
Right.
when he showed me the sign.
Right. But the signs were there, right? It's not like the signs weren't there. You saw them. You just think it's unfair, right?
Yes.
The irony is, it's a $250 deductible. You're suing for $2,000. Let's say $51 for 3 days of parking because your parking pass was on the car. I don't know why you wouldn't just take your parking pass. Maybe it's a sticker or something.
My parking pass is a sticker. It doesn't
Yeah, but you
come
could
off.
always get a
I have to
temporary,
tear it
right?
off.
But you could get a temporary. And then you want $1,700 in
cannot
pain
get
and
a
suffering.
temporary.
Why couldn't this be resolved with $250 worth of free car washes? Like, wouldn't that have been kind of peachy?
Like if you get a bad service
Ms.
somewhere,
Dookie,
are
I'm
you
not
gonna go
talking to you
back?
right now. Nobody in this
Okay.
crowd knows when to be quiet. I'm trying to help you. Okay?
Sorry.
I'm going to talk to the owner now. Ms. Carfora, why couldn't this be resolved with Green Light Car Wash just as a matter of customer service or whatever, by attempting to maybe give her $250 worth of free car washes or something? Was there ever any effort to do that just to keep the customer?
Yes, we attempted to do that at the beginning. She refused, and so that's when we started to do more research on her individually.
Okay, so hold on. When you say we attempted to do that at the beginning, I don't know what the beginning is. Are you talking about
When she filed the original small claims court.
Oh, okay. So not when the event happened, but when she filed a case. Who attempted to negotiate with her?
I think my husband.
Okay.
It was actually a mediation.
Yeah.
Mr. Carfora was there, and I was there as well.
Oh, tell me about the mediation. What did you guys offer?
We did offer the $250 in free car washes.
That's
and she said
exactly how I thought this case should be resolved. She refused it.
Correct.
Right. So here we are. Now, what did you just say about that's when I started to do research on her, Ms. Carfora?
So we did call our insurance company, and we identified her as the plaintiff. We wanted to get permission from them to go to small claims court. They agreed to help us, and they did an insurance service file number on her, and we found 10 auto claims, 5 workers' compensation claims, and 1 disability claim. So deep down, yes. So my concern, just from the bottom of my heart, is that if you have 10 auto claims, the mirror was probably taped on, waiting to go through the car wash so that she could collect this $2,000 for what? So that we could continue to let her have these claims? She's already on disability. Just 5 workers'
You don't know about her
compensation claims
disability.
and 10
You're
auto
implying that
claims.
her disability is illegitimate. You have no idea.
No, I'm not saying that at all. I'm saying I think 16 claims in a few years is
Are those? Do
unusual.
you have 16 car claims, Ms. Dookie?
I don't know what she's talking about, Your Honor.
Do you have any car claims?
I don't know. I don't think so.
Okay.
Where's it? Can she show it to me?
Nah, I don't really need to get in the weeds about that. It's because that's not going to affect my.
I don't know what she's talking about.
I'll tell you what this case boils down to. I believe that the car wash actually caused that mirror. When I say caused, I mean it was fine and then it's not fine. That is obvious to anyone with eyeballs who sees the video. I believe that the car wash is correct when they say that they have disclaimed liability for any cars older than 7. Why? Because cars older than 7 might have 16 car claims or 10 car claims or have been in an accident or be, have been repaired. Whatever it is, that's their policy. And those signs are out there, and you need to read the signs before you continue to give them your business. I don't know, and I don't really care about how many claims you have out there, although I got to say, that's a little salty, all those claims, but we'll just leave that to a side. I have no idea. I hear what you're saying. Oh, maybe it was, put together with spit and chewing gum. It doesn't matter, because at the end of the day, the car was built in 2013, and it's 7 years old or older than exactly 7 years old. So they are covered with that waiver. Every time you go in there, you see that sign, and that sign's there for a reason. That covers them. So I'm sorry that you're out that money.
But it says over 7 years old, and it's not over 7
It
years
is over
old.
7. You know what day it became over 7? 2020. October of 2020 when it was built. It was over 7. Okay? But no matter what, on January 1st of 2021, it's 7 in a day. honestly, you're out of gas based on those waivers, 100%. And I wish you had taken the $250 in free car washes, because you should have realized at the mediation that
I'm not going back to their car. Well, who
that's
would wanna
fine.
go
You
to
don't
a
have to
car
go
wash
back to
with
their
a-
car wash. You
a
don't have to.
car?
But then you would have had something. But
Please
that's
don't
fine.
come back.
You don't want to go back? Don't go back. Nobody has to go back.
You go
But
give it
I
to-
have to rule on based on what's in front of me, and
have.
based on what's in front of me, I'm ruling in favor of the defendants.
So the defendants prevail in this case. They do not have to pay the plaintiff $2,000. Ms. Dookie, you were out of gas before you even entered into the courtroom. What do you think?
Yeah, he can take that $250 worth of car wash and stick a bow on it and give it to his mother. Maybe she will want it.
Well, the point is you lost the case.
Yeah, I'm not going
the
back
judge
to
said
their
you
car
should have
wash.
taken that
So I
offer.
don't care.
Well, that's not surprising. Were you surprised to hear the information from the defendants about all these insurance claims you filed? You say there's nothing to
Yeah,
any of
she's
that?
making all that up. There's no such thing. She doesn't have proof of it. Go ahead and show it to me. She couldn't. So she's just making all that up. They're a liar. They're thieves. And nobody should go to green light car wash anymore.
Let's talk to the defendants now. You guys obviously did a lot of preparation for the report coming into court today. She really did have all those insurance claims? There was something to that, huh?
That's correct. There's an insurance service database that we were able to access, and we found them 16 claims. So I think we were trying to identify that we're dealing with basically somebody who's very talented in filing insurance claims, and this needs to stop.
Well, very interesting indeed. Anyway, bottom line, it turns out the sign you have at the entrance into your car wash put you in the right anyway. You were not going to have to pay her from that point. Were you aware of that? I think you probably were. Am I right?
We were.
That's correct.
Bottom line, does this kind of thing happen very often to a car wash like yours? I mean, is there much damage or not? Or is it pretty rare?
So we wash hundreds of thousands of cars a year in one of the most popular car washes in South Florida. And this doesn't happen often because we maintain our equipment, and when we damage somebody's vehicle, we do right by them. But we're not going to deal with these frivolous claims. We're going to fight every single one, and we're going to end this madness.
Very, very interesting indeed. All right. Well, listen, thank you very much. You are prevailing, and you don't have to pay her a penny. And that'll wrap it up for this case. Very interesting situation, don't you think, Harvey?
So, Doug, this is a really important case. There was a posted waiver here that cars over 7 years old, you take your chances. Those waivers are enforceable even if the car wash was negligent. So you got to think about that whenever you see a waiver like this, that somebody can be negligent and still not pay you for the damage.
My neighbors leave their shoes in the hallway at the top of the stairs. If one of us trips over them and gets hurt, can we sue them or perhaps the apartment management?
There you go. I like that thinking. Sue the deep pocket.
Yes, very good.
Here's the thing.
Because the guy in the apartment might be broke.
Right. So the first thing you do is knock on the door and ask them politely to put their shoes inside their house, which is what they should be doing. They should never be putting them in the hallway.
Right.
And if they don't do that, you could sue them if you trip and hurt yourself.
Right. Of course, they're going to deny that you ever told them that.
Right. So you make sure that you have a record of having told them that. More importantly, you should be making sure you have a record of telling the building management that.
Right.
Because if they know that there's a dangerous situation and they do nothing, that would be the basis for you suing them, because they didn't put the shoes out there. But if you repeat it, if you lay a record of having complained about it and they don't take care of it, then you would technically be able to. This is America. Anybody can sue anybody for anything.
Sure.
But you would have a righteous suit against the management if they did nothing about solving the situation.
Right. And another point to make about that is that management has leverage on them. You may not. You're just a neighbor. That noisy neighbor who won't shut the hell up about my shoes, right? But management can say, you know, you're going to be out on your ass if you don't
And in the end, if nobody does anything, I figure that, you know, if they can't find their shoes, they might start putting them on the inside.
That's alternative C. Alternative A, alternative B, alternative C. The shoes are gone. Okay.
This is the plaintiff, Elisa Brown. She says her former landlord, the defendant, owes her money he's illegally keeping of hers. And what he's doing is so against the law. She knows her rights. She filed suit in court, and she's pretty confident the judge will see her side of things today as she seeks the return of her hard-earned $1,000. These are the defendant's children, Anna Walters and Jim Shinko. They say the plaintiff broke her lease early and only paid a portion of her last month's rent. So their father owes this woman Zippo. Anna even tried being nice by offering the plaintiff a portion of her deposit back, but she ignored her, then turned and filed this lawsuit.
Oh, her?
No way. Their father is accused of not giving it back.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff says that the defendants were her former landlords, and she says that they have simply stolen her money and she wants some justice stat. But the defendants say the woman broke her lease, didn't pay her rent in full, and they owe her nada. It's the case of this landlord is ungodly.
Thank you, Douglas.
You're welcome.
All right, Ms. Brown, you are suing Mr. Chinko, who is here with Anna Walters, for $1,000, a return of a security deposit that you say they've wrongfully withheld. Tell me what's happening.
Yes, so I was a tenant of Joseph Shinko's for almost 4 years. I paid rent on time every month. On May 24th, 2020, my roommate at the time told me that she lost her job from COVID and that she would be moving back in with her parents. I said, I'm really sorry to hear that. Please inform the landlord immediately and we can start looking for a sublet. We had 3 months left on our lease. Joseph Shinko called me the next day asking what I wanted to do, if I wanted to end the lease early or look for a new roommate. And I said, I didn't know ending the lease early was an option, but that would be the best situation. It's easier for you to find a new tenant than for me to find a 3-month roommate. And so we made a verbal agreement that June, which was over 30 days, would be my last month, that he would list the apartment for July 1st.
It didn't occur to you that maybe you should follow up with an email or something to make sure you had it in writing or whatever? Now it does, right?
Of course.
Yeah.
I've been speaking to him for almost 4 years. You know, it wasn't something that occurred to me at the time.
Have you ever spoken to his daughter?
Yes. She used to live in the downstairs apartment, so I've seen her a few times.
Have you ever
and then she's
dealt with her in terms of rent or anything like that?
No.
Okay.
No. She stormed into my apartment once about thinking we had a leak, but that was the first time I saw her.
All right.
And then, so we made a verbal agreement that June would be my last month. And if he said if he couldn't find a tenant for July and August, that I would be responsible for paying.
Okay.
And I agreed to that because we both, were fairly confident that the apartment would be rented because it's in a great location. I then looked at the additional terms of the lease agreement. And I saw that it says tenant agrees to give the landlord 30 days notice of intention to vacate, which I was like, okay, great. That's more than 30 days. And then it said the security deposit is not to be used as the last month's rent. It's to be used as protection against physical damages or if excess amount of cleaning is necessary. So I abided by this. I paid June's rent with the expectation I'd be getting my security deposit back. I also had a text conversation with Mr. Shinko's son-in-law, or maybe ex-son-in-law. He lived downstairs too, on May 29th. I sent him photos of the apartment. I was trying to help in any way I could
to get it re-rented.
Yes, and I asked him, should I also be trying to find a sublet also?
What ends up happening? You guys do rent it for July, right, Mr. Shinko?
Got July rent from something else, yes.
Yeah.
However, her story and our story don't align.
Yeah, so you tell me your version of what it is that you told her she could or couldn't do.
Okay, well, first of all, I'm Jim Shinko, the son of Joe Shinko.
Oh.
So I never spoke to her.
Yeah, you both have power of attorney, so go ahead.
Okay, so thank you, Your Honor. From our position, we think anyway, it's reasonably straightforward. We do have a lease with the tenant. The lease clearly states the start time and the end time. The tenant did not honor the lease. As she stated, she left early in June. She did not pay the complete June rent. She did not pay July. She did not pay August.
What did she pay in June?
I think it was either $1,000 or $1,100.
Okay, what did you pay in June, Ms. Brown?
I paid $1,100. That was my portion of the rent. And my roommate who lost her job said that they could take her security deposit.
What's your roommate's name?
Felicia.
Did you guys return to Felicia her security deposit?
To my understanding, we have not.
Of course not, because if you didn't return hers, you're not going to return the other person's. So that means that you have the other part of June by virtue of keeping the security deposit. Because we're not talking, there's no damages in this place. So we're talking about breaking the lease and what the punishment should be for breaking the lease. And the punishment is, what are you folks out? You don't get to make a windfall, you just get to be whole. You guys are telling me that the person she spoke to, your father, can't speak for himself, Mr. Shinko?
Well, my father's 92 years old, and it probably would have been better if we spoke on his behalf. That's why we're here.
No, and I get that.
But
But the thing is that she's saying that she spoke to him and he conducts business matters, and he told her, yeah, no problem, we'll look for someone else. And then you guys did look for someone else and you found someone else. So were you personally involved in discussions with the tenant or no?
No, I was not.
Okay.
But I did clarify with my dad. There was no discussion, according to my dad and even my sister, about extending or allowing her out early.
Well, then how?
And again,
okay, so in other words, what you're saying is that she said, I'm getting out early, and that's why you re-rented it, because she, sua sponte, on her own, decided that she was going to, without permission, ended up leaving.
Well, from what I understand from my dad and Anna, we did not know. There was no discussion with her and my dad about getting out early. We found out from the what we call the building manager, which is Anna's ex-husband. We found out from him that she left. So there was no notice, as far as I understand, and there was no conversation.
Anna, at the time, was he your ex or was he your husband?
No, I haven't lived there since October of 2017, so he was my ex.
But he's still the building manager.
He does manage the building, yes.
So, Mr. Shenko, let me ask you this. How did you folks know to rent the place out if you didn't know you had to rent the place out? Because it turns out you got the place rented in July.
Well, we were lucky to get it rented in a couple of weeks, but my understanding is Andrew, who is my ex-brother-in-law, contacted my dad to let him know that the tenant left, and then he reached out to the realtor, and they were fortunate enough to get it rented. That's my understanding.
And according to you, Ms. Brown, that's not true. You helped to get it rented by taking pictures. And did anybody come and see it while you were there?
Not when I was there. I was staying at my boyfriend's place.
Okay.
But so I left June 15th. I took photos, and Andrew told me May 29th that they gave the listing to a friend.
On May 29th, he tells you that the listing has been given to a friend. May 29th. You have the text from Andrew.
Yeah, May 29th. And I even asked him, like, should I also be trying to find a sublet also? Because I didn't want to be, just in case. He said he'd let me know.
May 29th. Should I be trying to find a sublet also? I'll let you know. This is from Andrew. We are giving the listing to a friend who is a realtor. Hopefully we can rent it. You prefer us to rent it, correct? Yeah, I do. That would be for the best. I think it will get rented. I agree, and I agree. Thank you. What part of that is you guys not knowing she's leaving and not agreeing to her leaving?
Well, I think obviously the big disconnect then is when Andrew, when he did tell my dad, apparently, did he tell him, June 15th when she was gone or what? So
right.
I agree with you there. That says that she was.
But in any event, what a landlord would be entitled to keep of a security deposit is what you're out. The idea is security deposit is for damages. Clearly, we're not talking about damages in this case. If anything, according to her, she's given us pictures where she left it better than she got it. Let's look at the pictures a second. When she got it, there was a wall that wasn't painted, and the landlord refused to paint it. What? No, did you refuse or did your dad refuse?
No, neither one refused.
Yeah, exactly.
Actually, if you look at the lease, the lease says she's taking it as is.
Okay.
And my understanding from my dad is she wanted to paint that one particular room or that one particular wall.
All right. Is there any question about the condition that she left it in? These are her move-out pictures, and it looks pretty good. There's no damages, actually, right? Okay. It's all about breaking of the lease.
I think.
All right. Let me ask Ms. Walters. Ms. Walters, can you explain to me if you guys ended up renting it out for July, you didn't miss July, You didn't miss any other months. It's rented. And you didn't, when you say.
It's rented at a lesser amount.
What amount is it rented at?
2,000. I sent the evidence of the
And what were they paying?
2,100.
Okay, so it's rented at $100 less. So certainly you should be able to keep the $100 that you're damaged, the $100 for July and the $100 for August.
And
August,
we got
correct,
half of
yes.
June. Your
You
Honor.
did not get half of June. You keep saying that, but here is the issue with June. She paid $1,100, and you guys kept the other girl's $1,000 security deposit. You didn't return Felicia's security deposit, did you, Anna?
No, but
Right.
as stated, that last month rent is not supposed to be a security
No, it's
deposit.
not, but it was. See, she's not a thief. She paid her rent. Lots of tenants just say, "Oh, I'm using her security deposit." She didn't do that. But the other tenant who had lost their job and left, you never gave her security deposit. So you're enriched by that $1,000. That $1,000 goes to paying June rent. You understand that, right?
Why doesn't she have to pay her ex-roommate then? That doesn't make any sense.
I don't know what you're saying.
Welcome back to the People's Court. The plaintiff seems super confident that she's going to get back $1,000. Well, let's see what the judge thinks.
Why is she entitled to use her?
Because her
roommate's
ex-roommate
security
bailed on
deposit?
her the same way she's bailing on you. She has to give you notice that she's leaving, that 30 days notice that we're talking about, right? And we'll talk in a second about whether she had permission or not. So her roommate has an agreement not to leave her in a lurch. So you've lost $0 for June, and you've lost $100 for July, and you've lost $100 for August. The lease was supposed to end at the end of August, correct. Ms. Brown?
Correct.
So that means you should be able to keep $200, but you've kept $1,000. And by the way, did you guys ever even send a letter within 14 days laying your claim to the security deposit and saying why?
She didn't.
Yes or
comply
no?
with the terms of
yes
the lease.
or no? Yes or no?
No,
Did you?
absolutely
All right.
not,
I
because
need
we
you
did
to
not
know.
believe that she
No,
was
I need
entitled
you
to
to
it.
know. No, you need to know that that's the law in your state now. New York requires you to send a letter as the landlord, and have proof that you sent it. So I'm just telling you this for the next time. Within 14 days, et cetera, et cetera, et cetera, which you guys also didn't do. But that's not even why I'm ruling the way I'm going to rule. I'm ruling the way I'm going to rule because if I don't, you have a windfall. I think you feel it because she's breaking it. You should get a windfall. I guess that's how you feel. Right, but you don't.
Right.
That's not what the law does. The law makes you whole and makes sure you're not hurt. You are hurt to the tune of the 100 and the 100. Are you hurt to the tune of anything else?
If the terms of a lease don't apply, then I guess not. But
No, they
why
apply.
have a
That's
lease
why
agreement?
that's why she can't just willy-nilly run off. There's things she's got to do. Like, for example, speak to the property manager who has apparent authority because he's the property manager, but also she spoke to your dad. There's uncontroverted testimony that she spoke to your dad. You guys are telling me, well, dad says she didn't, but there is a text from May 29th from your ex telling her we're giving the listing to a realtor. So clearly, there were discussions way before you think there were discussions. There were discussions in May because she spoke to your dad in May, then speaks to Andrew and gives him all the nice pictures of the apartment to help with the rental. And then here is what Andrew says. Let's read it again. May 29th, he says, "Thank you so much for the pictures." She says, "No problem. Should I be trying to find a sublet also?" Because she doesn't want to get in trouble. She's trying to do the right thing. And then he says, "I'll let you know. We're giving the listing to a friend who is a realtor. Hopefully we can rent it. You prefer us to rent it, correct?" "Yeah, I do. I think that would be for the best. I think it will get rented." "I agree and I agree. Thank you." All right. So maybe you didn't know about this. Did you know about this or you had never seen this, Ms. Walters? Right. Okay. All
I
right.
have not seen that.
So it looks like she had discussions with your dad beforehand. See, technically speaking, you shouldn't be able to hold on to any of the security deposit because you didn't send out that letter in 14 days as the law requires. But I find that in this case, that requirement was waived because clearly the plaintiff made an agreement with your father that if he was out any money, she would recompense because the agreement was if you can't rent it out, I'll pay rent. The only thing that you can keep as a landlord in court is your damages. And what are your damages? From what I have heard, your damages are $200, not $1,000. And she's right to keep the $200 of it because she's rented it out for less. Okay, so I'm going to order them to return $800 of your security deposit, Ms. Brown. Okay?
Great.
Your Honor, can I?
Good luck,
ask a
everybody.
question?
So the plaintiff prevails. She'll get back $800, $200 less than what she was seeking. Mr. Shinko, you wanted to ask the judge a quick question before she walked off the bench. What did you want to ask her?
Well, I wanted to ask her that there's no proof that the other tenant gave permission for this tenant to use her deposit. So that's the part I don't understand. Why shouldn't this tenant share half the responsibility with the other tenant? That was my...
Well, either way, the only thing you lost was the $200. So let's find out now how Ms. Brown feels about the outcome of the case. Ms. Brown, you didn't get $1,000, but you're getting $800. Was it worth filing the lawsuit?
It was. I forgot to mention that Anna did call me after I gave them the security deposit demand letter. You know, they said that they told me it wasn't worth fighting, and it was. So I'm happy I did it.
Good. Congratulations. It was worth it for
you. Thank you.
Okay. All right. That'll bring this case to a close. Let's see what Harvey thinks. Harvey?
So, Doug, this is a pretty standard principle that sometimes somebody can owe you money and then you end up settling perhaps for less. That settlement sticks, and you can't get a second bite of the apple and go back in and say the person owes you more. When you settle, you settle.
Have the judges had any specialized training in human behavior that would help them determine if a person is not being truthful? How do you guys figure it out?
Every single case that comes before you in the courtroom is the clash of two different versions of the truth to some extent, right?
Yeah, most of them. And, most every single one.
Boy, if there was just some magic way to figure it out. But I do look at certain cues come to me, like if somebody's testifying and giving me this account of what happened, and all of a sudden they start throwing in things like, to be honest, or to tell you the truth, like, you know, that doesn't need saying. You're under oath and you're testifying in court. Okay, don't throw that in now. And, you know, you look for, things like, are they making eye contact? Aren't they? Do they suddenly change their head? Does their breathing change? Does their voice change its timbre and tone? But that stuff's not really reliable. So at the end of the day, judges are going to look at, is the testimony internally consistent so that it kind of flows? And does it square with the evidence?
Right.
Is it corroborated?
Right. Everyone thinks there's some magic, bullet there where you just, their eyes shifted. That's not really how it works. It's the facts, the facts, the facts. So you go back and forth and you cross-examine, and you know something they said before, and then they say something different, and then you cross-examine them with it, and then you watch how they weaken, and then you watch how they crumble.
Well, that sounds like you and me when I'm trying to get one by you.
Yeah, that doesn't happen.
But I have taken a polygraph.
You did? You did?
Took a polygraph exam. I was only about 16, 17 years old when they hooked me up.
That's ridiculous. I would never let my child. For what? What job did you take a polygraph?
It was a store I worked at when I was in high school. I was like a sophomore.
And something went missing?
High school. Stuff was going missing. I was walking out, probably out the back door of the store, and they took each one of us in turn into the break room. Like, you didn't know it was going to happen. Nobody said you're going to take a polygraph. You just came in. They said, "Come on in here."
Days.
Came in, boom. You sat down. They hooked you up. They asked you all the questions, etc.
You sure it was a polygraph? Didn't they? Maybe they just hooked you up to a Jiffy Pop, and you think it was a polygraph because you were so young.
I watched the needle movement and everything else.
And how'd you do?
Well, I'm still a free man, right?